All right. Well, thank you.
Oh,
Let's
there we
see.
go.
Let me share
So
my
I'm
screen.
mm, I'm going to introduce our speaker today. We are so fortunate to have Margot Parker Elder with us. She is the Director of Outreach at the Housing Rights Center, and she'll be presenting a housing rights workshop with us today. So thank you so much for being with us.
All right. Well, thank you. Thank you, everyone, for being here. Hopefully, everyone can see my screen. Um, I am Margot, and I'm the Director of Outreach at HRC. And let's keep going. So, first, I'm going to start by introducing the Housing Rights Center. For those who may not be familiar with us, we are a nonprofit that works towards fair housing, meaning equal access to housing, civil rights in housing, and working against discrimination in housing. So, fair housing exists in the US as a law and as protections for people, really because of the civil rights movement. We were actually founded in 1968, which is the same year that Congress passed the Fair Housing Act, also known as Title VIII of the Civil Rights Act. And so that's when it became the law in the US that a landlord or a housing provider cannot discriminate based on race, nationality, or religion. And then over time, more and more protections have been added that we're going to look at today. And so we ourselves work in LA County and Ventura County, but the protections, specifically the fair housing protections that we're going to talk about today, apply much more broadly than that. And so our services are free and available in multiple languages. And one of our main services is housing counseling. And so housing counseling is available for people to receive information on their rights, so you can be empowered to decide what you want to do and know what your options are in a given situation. So people call about evictions, rental increases, harassment, all kinds of different issues, as well as discrimination. So I have our information on the screen. And if you do want to reach out to one of our counselors and talk one-on-one, you can get more information about your situation and your questions. A lot of the time, people call us and they don't realize that what they're experiencing is discrimination or illegal, but our staff is trained to screen for that. And in those cases, we can often take on that case and do an investigation to root out that discrimination and advocate for that tenant. A really common thing that we help with is getting accommodations for people with disabilities who maybe need something different in their home, and we'll talk about that today. And so, what is fair housing? Fair housing is the ability of people of similar income levels to have available to them the same housing choices, regardless of personal characteristics such as race, national origin, religion, and many more protected classes that we're going to talk about during this presentation. And so when we're talking about fair housing, we're referencing the Fair Housing Act, which is a nationwide federal protection. But additionally, in California, we have more protections in the form of California's Fair Employment and Housing Act, as well as laws such as the Immigrant Protection Act and the Unruh Civil Rights Act. So there's many laws, but we're going to just cover the core ideas here. And so fair housing laws apply to basically, it doesn't matter if you're renting, if you're buying, if you're lending, if you're just thinking about, seeking out a new housing. Fair housing laws apply in all of these transactions. So it's not just the person who's already on the property or has a home, leased. It's at all these different points. It also really doesn't matter what type of housing you're living in. You have protections in apartments, in condos, in houses, in duplexes, residential motels, even shelters in California, mobile home parks, and even vacant lots if they're being used for housing or short-term rentals. So one thing to point out though, is that there are limited exemptions under California's law, meaning that there's a few situations where properties are exempt to the fair housing laws that we're going to be discussing. So exemptions may include, senior housing that actually is allowed to just seat people over a certain age, which would normally be illegal. Also, owner-occupied single-family residences, meaning the owner is living on the property and maybe they're seeking one roommate who's of the same sex. In that scenario, they may be able to ask, in their advertisements of someone of a specific gender. Additionally, some religious organizations' housing can be subject, certain fair housing laws don't apply. And so if you have a question about one of those specifically, I'm happy to answer them in the chat after. But let's keep moving on. So responsible parties, and these are all the people who are responsible for making sure that everyone's fair housing rights are being upheld. So they include anyone who's working for the housing, meaning not only the property owner, but also the property management company, the on-site managers, even administrative and maintenance staff. They're all responsible. And liability flows upward from the maintenance and administrative staff all the way upward to the owner. And so everyone is responsible, but ultimately it's the owner who is ultimately responsible for making sure everyone's fair housing rights are being respected and upheld. So this can include property owners, property managers, and even homeowner associations or real estate agents and brokers. So let's move on a little bit. So now that we've talked about who is responsible, let's get into who's protected by these laws. So under Title VIII of the Civil Rights Act of 1968, commonly known as the Fair Housing Act, or FHA, which is a federal and nationwide law, we have protections based on certain classes or characteristics. So the Fair Housing Act prohibits discrimination in the sale, rental, or financing of housing based on the following. First, we have race. So the Fair Housing Act was passed, when people of color, more specifically African Americans, experienced widespread and unchecked discrimination in housing. While the vast majority of these claims have alleged discrimination against Black individuals, the Act's ban on discrimination, quote, because of race, protects individuals of all races. So next we have discrimination based on color, which means discrimination based on skin tone. We can imagine that someone's skin tone is not necessarily tied to their race, and discrimination can occur between people of the same race based on colorism. So next, the Fair Housing Act also prohibited discrimination on the basis of religion since 1968. So discrimination by housing providers against religious groups or against particular sects of a religious group are unlawful. It's also illegal for landlords or other housing providers to treat in-place residents differently because of their religion or because they are agnostic or atheists. It could be, religious discrimination can also include like advertising statements that give an impression that a certain religious group is preferred, like conveniently located near XYZ synagogue or church or temple. And it can also be, something that we wouldn't always think, which would be maybe allowing one tenant to display Christmas lights and other decorations while refusing to allow residents of other religions to decorate in celebration of their own holidays. So next we have sex. The prohibition against sex discrimination should be understood to ban the same types of practices that would be illegal if undertaken based on race or any other protected class. That means that all apartment managers or housing suppliers must lease, sell, and negotiate with women on the same basis as they do with similarly situated men. So examples of this type of discrimination include taking or treating a couple's aggregate income less favorably than a family where only the husband works. It can also include discounting alimony and child support payments received by a divorced woman. So the Fair Housing Act's prohibition on sex discrimination did not originally include sexual orientation and gender identity as prohibited bases. But in a 2020 case, the Supreme Court held that sexual orientation and gender identity are included in this prohibition against sex discrimination. So there are two types of unlawful sexual harassment, which is quid pro quo, meaning this for that, as well as creating a hostile environment. Hostile environment within sexual harassment occurs when a sexually offensive behavior is sufficiently severe or pervasive enough that it interferes with the person's use and enjoyment of their premises. So moving on, we are also protected based on our nationality or our ethnicity, which the law calls national origin. Claims based on national origin discrimination are distinguishable from citizenship claims. So the Supreme Court has noted that the term national origin refers to the country where a person was born, or more broadly, the country from where his or her or their ancestors came. So the issue in a national origin case is whether the defendant, the person experiencing discrimination, whether that defendant, or actually the defendant would be the property manager, but whether that person is discriminating against everyone or just people from a certain country or heritage and not others. So moving on, familial status is whether or not we have minor children in the home. So that includes protections for pregnant women, foster families, and grandparents. It's different from marital status, which is a California protection, which protects us from discrimination that's based on whether we are married to the person who's in the other unit. So that would be marital status, but this is familial status, which means having minor children in the home. So we're going to touch on this one a little bit more in a few slides. And then lastly, the FHA also added that nationwide we are protected based on having a disability, a mental or a physical disability is all protected. So we're going to dive into these more in more detail in a few slides. So let's continue. So familial status, what does it mean? So basically, it's important to point out that it is not only a protection offered to a parent and their biological child, it's really any family configuration. So any household where there's a minor who lives with an adult who's responsible for taking care of them, that's also what it means. So households with one or more minors living with a parent, legal guardian, or designee with written permission. As we talked about, it also includes households that are expecting the arrival of one or more minors, meaning adoption or pregnancy. And we see a lot of discrimination towards families with children every year. It's one of the top complaints across the nation. And examples of this discrimination may include like locating or placing families with children in a certain part of the property. It could also mean not allowing families with small children to, let's say, rent on the second unit or second floor unit, maybe because they're concerned about safety, or maybe because they're assuming children run in the upper units and will make too much noise. That's actually illegal. That counts as familial status discrimination. So other times, familial status discrimination can take the form of imposing unreasonable occupancy restrictions or setting restrictive rules or saying children have limited access to the services or facilities. So maybe there's an overly restricted rule that says children cannot use a common area that everyone else is allowed to use. This would be an example of illegal discrimination because it targets families with children and has the effect of making them not feel welcome, or even worse, does not allow them to use or live in the property at all. Ads that say no children or adults preferred also count as illegal discrimination. So moving on, I also want to talk a little bit more about national origin. National origin could mean someone's country of birth, which we talked about a little bit. They were born in a different country, but it could also mean ethnicity, which is not necessarily tied to a specific country, like, for example, being of Asian descent or being of Latino or Latinx descent. It can also cover physical or cultural traits, including clothing or hairstyles. So if your landlord's pointing out and making you feel unwelcome, based on what you're wearing, that's a culturally, specific item, that would count as discrimination. And it also includes people who speak a language other than English, or maybe they speak English with an accent. All of that is protected against discrimination under federal law. So here we have some examples of discrimination, and they're laid out here. So maybe it's denying a rental application because of a tenant's language or accent, or charging a higher security deposit because a client is undocumented, or harassing a tenant with ethnic slurs. So all of this would count as discrimination. All right, so everything that we have just talked about are federally protected classes or characteristics, meaning everywhere in the nation we have those protections. But in California, we have another fair housing law called the Fair Employment and Housing Act, which was passed in 1958, and this gives us more protections. So these protections include ancestry, marital status, which we talked about, sexual orientation, gender identity and expression, source of income, which is a big one, which I'll talk about more in a second, medical conditions. So maybe you have a pre-existing medical condition, you're protected in California from discrimination in your pursuit of housing. And then we also had military and veteran status. And then we're going to talk about a few more in California after this section. So here we have source of income discrimination. So this is a big one. What does it mean? So when we talk about source of income discrimination, the California Fair Employment and Housing Act, as well as SB 329, say that a tenant's lawful source of income, so lawful meaning, it's not coming from a criminal avenue, for example, but that tenant's lawful source of income cannot be the basis for differential treatment. And so this is relatively new. This came about in 2020, actually. And so, for example, maybe you're using some type of rental assistance or receiving some kind of subsidy, alimony, child support, financial aid, and very importantly, public benefits such as SSI, SDI, GR, or any kind of rental assistance. If you're using, those types of public benefits in California, a landlord is not allowed to refuse an application because a tenant receives one of these types of assistance. So they are not allowed to advertise no Section 8 or refuse to accept or approve applications from tenants with Section 8 housing choice vouchers. So being told from a landlord, no, I don't take a voucher, that's not legal in California. So here we have some examples of discrimination that falls under source of income. It could be something as simple as saying no Section 8, advertising statements saying no Section 8, but often, landlords will use other tactics to make sure that, people receiving these types of housing choice vouchers, aren't renting there. So maybe they delay or they refuse to accept or approve applications from current tenants who, are saying, hey, I received this finally, I would like to use it, and they don't file the paperwork for years. So that's a common example of source of income discrimination. It could also be applying income standards incorrectly. And so let's talk about that a little bit more. So income standards must be applied to the tenant's portion of the rent only. And so this is important. So if there is an income standard in the rental application, like for example, if they say you have to make 2 times the rent or 3 times the rent, which is allowed, that standard can only be applied to how much of the rent the tenant has to pay. So their portion of the rent. So basically, let's say they were making $300 a month. Let's say Joey's making $300 a month at his part-time job. Joey has a housing choice voucher that pays $900 a month. Joey applies for an apartment where the rent is $1,000. The application says tenants must have 3 times the rent. Does Joey meet the income requirement? And so what do we think? Maybe I'll take a look at the chat really quickly. It's a little bit hard to use, so I understand. But in your head, try to think, what do I think here? Because the truth is, Joey does meet the income requirement. And so because he's making $300 per month at his part-time job, and he only needs 3 times the rent, he's receiving $900 a month in assistance. So his portion of the rent is actually only $100. So in this scenario, by making $300 a month, he's making 3 times the rent. All right, and so let's continue on. And side note is sometimes, landlords who don't want residents using, a housing choice voucher, they'll sometimes take and employ other tactics. They won't say no Section 8 over the phone, but they'll do everything they can to not accept it. Criminal background checks and, intensive screening. And what's important to remember here is that if they do that for one applicant, then they have to do that for all applicants. So that's where the discrimination can really occur. And if you feel like, you've ever been in this type of situation, this would be a really good example of when to reach out to the Housing Rights Center, because these are the types of cases that our testing department can go into. They would pretend to be, a prospective applicant, and they would see what would happen there. And they would basically collect some evidence and make a case. All right, so moving on. California has some additional protections shown on this slide. So tenants who have survived domestic violence or other violent crimes can change or request the locks to be changed with little notice. You could also break your lease if you needed to move somewhere else with lower penalties. There are protections in California based on immigration and citizenship status. So, for example, if you don't have a social security number and a landlord or a provider wouldn't be able to run your credit, you should be able to provide some alternative form, a financial history, just something to show that you pay your bills on time and you'll pay your rent on time in the future. So something that doesn't require a social security number. And I'll touch on a few more protections in California that come from the Immigrant Tenant Protection Act, which is AB 291, in a later slide. We also have protections in California for age. And age here is referring to adults who are over 40 years old. So over 40 years old, and you have protections in California under age discrimination. So when it comes to minors and when it comes to under 18, that's familial status. And so under the Ralph Act, California civil law prohibits hate violence and intimidation by threats or violence. And I want to make sure that we have enough time to get through everything. So I just want to highlight that, if one of the languages that you speak is one of the languages listed on the screen here as your primary language, you are allowed to bring an interpreter with you to help you understand the lease before signing. So the interpreter doesn't have to be a professional. They could be a friend or a family member or just someone you know. And you also can request a translated copy of the lease at no cost. So your landlord would have to provide that. And so the goal here is to make sure that people can understand their lease and that they're not going to be exploited signing a lease that they don't understand. So now let's zoom in a little and cover a few more protections in detail. So first we have the Immigrant Tenant Protection Act, or AB 291. Through this act, California landlords, as we kind of talked about, are prohibited from reporting or threatening to report tenants to immigration authorities. Landlords are not permitted to ask about your immigration status on a rental application, and tenants are not required to tell their landlord about their immigration status at any time in the rental process. Landlords or providers cannot threaten to tell authorities about a tenant's immigration status in order to force them to move, retaliate, or harass them. Landlords cannot evict tenants for not having a valid social security number or state-issued ID card. So if a landlord discloses or threatens to disclose a tenant's immigration status, they have the right to sue, also called a private right of action. All right. And so now moving on, disability is a big part of this presentation because it is much broader than you might think. So disability is a physical or a mental condition that makes it more difficult for someone to do certain activities. Beyond the word's commonly understood meaning, disability is also a legal term with a specific definition under both federal and California law. California's definition of disability is broader and more inclusive than the federal law's definition, and it's defined as, quote, a mental or physical impairment that limits a major life activity. And so federal law defines it as a mental or physical impairment that substantially limits a major life activity, but California just says it just has to limit it. It doesn't have to be substantial. So disability protections in fair housing are not necessarily about a specific diagnosis. The diagnosis actually gets to stay private throughout your whole tenancy, and you never have to disclose your disability in order to get disability protections. So what you do have to talk about, though, are your symptoms, because disability is defined by the impact on the individual. It does have to come from a physical or mental, quote, impairment, as the word of the law uses, a condition that's physical or mental that puts a limit on your mental or your major life activities. So it limits your ability to see, hear, walk, breathe, perform manual tasks, care for yourself, learn or speak, or even more. And so here are some examples, and then here are the types of causes that could potentially have these types of impacts on the individual. But for every individual, it may be different. So one person, with autism or on the spectrum does not necessarily have the same limitations or experiences as another person, with autism or on the spectrum. Same with HIV, same with anxiety, substance use disorders, right? So it's based on the individual's experience, and that's very important. So individuals with disabilities face many obstacles to securing, using, and enjoying housing. Fair housing and other laws aim to reduce these obstacles, in part by codifying the rights of people with disabilities to be free from discrimination in housing. So this includes the right to request reasonable accommodations and modifications. Housing providers, in turn, are required not only to refrain from intentional discrimination, but to also avoid policies and practices that unintentionally discriminate against people with disabilities. And so to avoid unintentional discrimination, this may mean making exceptions to rules or policies that would otherwise have a discriminatory effect on individuals with disabilities. So these exceptions to rules or procedures are known as accommodations. And in some instances, housing providers must take even more proactive measures, such as allowing structural modifications like a grab bar or designated parking space to further fair housing rights and ensure individuals with disabilities can get equal use and enjoyment out of their housing. So both federal law and state law provide significant protections for people with disabilities. California law, however, not only explicitly incorporates federal law as a floor of protection, it also goes beyond that to add additional protections. And rather than needing to know each applicable law, it's more important for tenants as well as housing providers to understand the basic common rule that both overt intentional discrimination and unintentional discrimination through policies and procedures that do not accommodate people with disabilities are not permissible in housing. And so when a landlord is considering the question, does this reasonable accommodation or modification request have to be granted? They are required to use the following basis to determine their answer. And so number one, is it necessary for the tenant? So is this request directly related to the tenant's disability? And this is important. Does it improve the accessibility, safety, quality of life, or at the very least, enable them to live there at all? And so the second consideration, this is the first one, is it necessary? The second one is it reasonable for the landlord or the housing provider to grant? So in other words, can they grant it feasibly without it creating some kind of excessive burden or cost or work for the staff that the landlord has to do? So if it does, become too much of a burden, it's too excessive or too big of a change to the nature of the housing, then the landlord does not have to do it. So there's basically a threshold, and it differs on a case-by-case basis because each person's disability is different and what they need is different. So what's feasible at one property might not be feasible at another property for many different reasons. So it's very, very individual. Now the landlord can, and in many cases, will ask for verification, that the tenant needs their request because of a disability. The verification should not include a diagnosis since this is the tenant's private medical information. It just needs to say that because of the disability's impact on your life activities, the tenant needs the accommodation or modification they're asking for. That's it. So it doesn't necessarily have to be a doctor's note, but it is recommended that it is a doctor's note since that's the strongest form of verification, especially if you're going to need to pursue legal action. But there are times, when that's not feasible. And so it can come from a reliable third party that's familiar with the tenant's disability. So that could be a social worker, or a therapist, or just anyone who can really vouch that they're suffering these impacts and would benefit from the request. But the truth is, we often try to recommend that people, try to secure a doctor's note, just because if you do have to pursue legal action, that's going to be pretty much what you're going to need. And so if a landlord cannot reasonably fulfill the request, they received all this information and they, really considered, is it necessary? Is it reasonable? And they decided, you know what, we can't fulfill the request. So if that happens, they must engage in a good faith dialogue with the tenant to find a reasonable alternative. So they can't just not respond to you. They have to have a dialogue with you and really try to work with you and figure out what they can offer. So now let's look at some examples and try to make this a little more concrete. So once again, an accommodation is a change to a service or policy. So it's a rule or something that is not a physical change. For these types of requests, the landlord bears the costs if there are any. So some examples are, maybe a tenant receives disability assistance and it comes on the 5th of the month, but the lease says that rent is due on the 1st of the month. So because they're receiving assistance from the government or a nonprofit based on this disability, we know like right off the bat that that's directly related to their disability and that they already have verification because they're eligible for that program. So that means that they have they have a disability, and with that information, they can request to the landlord that they be allowed to pay their rent on the 5th of the month or maybe the 6th, whatever would make sense. So every situation is different, but most likely this is not going to be too unreasonable for the landlord to grant, since this is an exception for one person based on their disability. So another common example is someone requests a support animal or service animal. A service animal is usually a dog, and it's trained to provide some specific medical function, like maybe it detects seizures or peanuts, and it does have a specific certificate because it has to pass that training. So an emotional support animal or a therapy animal doesn't need any special qualification. It's just about the relationship between the person and that animal. So again, the person has some kind of disability or impact on their ability to function, and they need that animal to function. So some other examples of reasonable accommodations include requesting an accessible parking space, requesting to transfer units or have a live-in caregiver, or even ending the lease early or extending time to vacate. So here we have 2 asterisks, and that's because in these requests, though it says that the landlord pays, you actually may end up having to pay. Because let's say, you're switching units and it's a bigger unit on the ground floor, they would have to charge you more for that unit if it has, more square footage or something like that, an extra room, let's say. So now requests for modifications, which is something that's physical or structural or some kind of change to the building, either inside or the exterior or common areas. For this request, the tenant pays the cost and may have to reverse or change it back to its original state when they move out. So, maybe they're asking to install a wheelchair ramp or grab bars or low countertops or a visual doorbell. They may be asked to put it back after. Often though, if it's a wheelchair ramp, you could make the case that it makes the building more accessible. And in that, situation, they may say, leave the wheelchair ramp. We don't have to put it back because it makes future residents able to access our units. All right, so moving on. Oh, and the only exception is in federally funded housing, where actually the tenant would not have to pay for the modification. And so we have a little bit more information on this in this slide in case anyone is curious about this. So this is where recipients of federal financial assistance, are supposed to make adjustments to the structural environment as part of making the program and activities available to the person accessing it with disabilities. So if the requested modification is reasonable and the individual has met all the requirements by law, it would be disability discrimination for the housing provider to refuse. So here we go. All right, and so now we're moving on to the next section, which is practicing fair housing. So here's just some general information. If anyone here is a housing provider, or you just kind of want to understand a little bit what's allowed and what's not allowed. Housing providers should never base a rental decision or provision of service on obviously the protected class of that individual in question. They should never base the terms, conditions, or privileges of a rental on the basis of a person's belonging to an affected class or advertise in a manner that states or suggests a preference. So they should always apply all the standards in an equal manner And if they have a waiting list, let's say they have an established procedure to rent available units, and they should not vary. So you may be asking, what can they screen me for? What can a landlord screen me for? And so basically, these are the considerations that you can be rejected for on the basis of one of these things. And we do get this question a lot, so we want to make that clear. They can essentially try to figure out, can the applicant, pay their rent? Have they paid their bills on time? Have they been good tenants? And all of these things, that's when they can ask about income level, they can inquire about credit score, they can ask for references from a past landlord. Smoking status, they can have a no smoking policy, that's allowed. They can also have a no pet policy with the exception for disability accommodations, which include service and support animals. And so now criminal history is something that landlords can ask about. However, they really have to consider it on a case-by-case basis. So they cannot just say that, anyone with a record or anyone who's been arrested cannot rent here. So they can't say anything like that. You have to have an opportunity to explain. And, if you do have a record, you might want to explain things like, how long ago did this happen? What kind of incident was it? Maybe it wasn't anything that would really, be concerning for safety. Maybe the person is in anger management or went to rehab. So it would be helpful to explain what has happened since then. And all of those things matter in determining if there's cause for concern for safety or property damage. So you can imagine that there's a lot of criminal history that does not cause concern and should not be the basis to reject someone. So the property may also have, as we touched on, any of these things that they can have, but they should enter into a dialogue with you specifically about criminal history. So now that we've covered who's protected, I also want to give some examples, of what actions are actually illegal discrimination. So it's important to remember that it's all only discrimination if it's based on the characteristics that are protected. So it's unlawful to discriminate, just by flat out refusing to sell or rent housing, saying the housing's unavailable when it is available, having different terms or rules or conditions for people, of a certain age or belonging to a certain class or group, discriminatory statements or advertising, saying this is a single professionals community, like that would be a discriminatory statement. Steering, which is a term used, or it's actually a discriminatory practice that encourages segregation based on steering members of a protected class away from buildings or neighborhoods inhabited primarily by members of another protected class group. So maybe a mother and child are looking for, new housing, and the real estate agent says, there's better schools in the neighborhood next door. That's actually an illegal practice known as steering. So it can also be discrimination based on association. So maybe you yourself aren't transgender, but your landlord's discriminating against you because you're having friends over who are transgender. That also counts as prohibited practices. So it can include threats, intimidation, harassment, and retaliation, denying a reasonable accommodation or modification, or otherwise any action that makes housing unavailable. So that's kind of the catch-all there. All right, so I'm going a little quickly now, so we have just a little bit of time to talk about rent and evictions. And this section is just basically, I'm going to provide the PowerPoint after, so you can always reference it. And there are a few links in here. So basically, we're going to cover just a few major protections in California, and more specifically Ventura County. So rules about rent increases and evictions depend on many factors. So for example, the number of units, the age of the property, corporate ownership of the property. And what this means is that in the same city, some homes have protections while other homes do not. So limits on rent increases come from local rent stabilization ordinances, which are known as rent control. And the way you can figure out if your property is under rent control is you could call your city or you could call HRC. And at the end, I also have some additional resources that Ventura residents can access. So the California Tenant Protection Act, also known as AB 1482, covers many homes across California without local rent control. So often you would first want to check, is my property under an RSO, also known as a rental stabilization ordinance? And if not, is my property under the California Tenant Protection Act? And so right now, Oxnard and Ojai in Ventura County have their own RSO, which we'll touch on in a few slides. And so properties that generally do not have rental protections include single-family homes owned by an individual or family, subsidized income-restricted housing, and institutional housing, for example, dormitories or medical facilities. So covers many homes, but you do have to look up and see if you qualify. And so this is just information about the California Tenant Protection Act. If you did fall under this, protection, your property would fall under it, not you actually. Specifically, it applies to multifamily, 3+ units over 15 years old, duplexes not occupied by the owner, and single-family homes or condos owned by corporations. So in Ventura County, if you're under the TPA, the maximum yearly rental increase is 9.2%. And that is until August 1st, 2024. And so also under the TPA, it doesn't only talk about rent control. It also lays out two concepts called at-fault evictions and no-fault evictions. And so at-fault evictions are things where it actually is the tenant's fault that, they're being evicted. And maybe that's property damage, not paying your rent, breaking the lease, threats to health or safety, criminal activity. These are things that are normally outlined in your lease that would constitute an eviction. But no-fault evictions are demolition, remodeling, the owner moving in, and these scenarios where it's actually the owner or the landlord's fault require relocation assistance equal to 1 month's rent. And so this is the TPA, but we're going to quickly also talk about some specific Ventura County information. So here we have some mobile home protections, which I'm actually not going to cover because we're a little short on time, but the information is here. If you're in a mobile home, you can read this over after. Basically, depending on where you are, like Oxnard has its own rules, Thousand Oaks has its own rules, and unincorporated Ventura County has its own rules. And so here's also a handy link, and I'll share the slide after, to see more information about Ventura County's mobile home park rent control program. And so if you do have a problem and you're in a mobile home, here's also the information on who to contact. Next, we have Oxnard's Rent Stabilization Ordinance. So this one went into effect on June 2nd, 2022. It applies to the same type of properties, multifamily 3+ units, built before February 1st, 1995, duplexes not occupied by the owner, and single-family homes or condos owned by corporations. And so if your property falls under Oxnard's rental stabilization ordinance, your maximum yearly rental increase is actually only 4%. And so they could only increase the rent once every 12 months, 4%. So the exemptions here would be government subsidized housing, mobile homes, which are already covered under the city's mobile home RSO, and then institutional properties like dormitories, hospitals, and group homes, and then owner-occupied units, including duplexes where the owner lives in one of the units. So if you have a complaint, here's the information on who to contact. In Oxnard, just like the TPA, you also have just cause tenant protection. And so this outlines, the just cause evictions. as well, as the no fault or the at fault evictions. But here it's important to notice that in Oxnard, this part of the ordinance, so not the rental part, but the just cause evictions part, kicks in after 30 days of tenancy. So the TPA actually takes much longer than 30 days. Also, in Oxnard, if it is a no fault eviction, which means, maybe the owner is moving back into the property or taking the property off the market, you actually get more money than under the TPA. You get 2 months of rent or $5,000, so whichever is greater. And so for more information, there's actually a good City of Oxnard frequently asked questions flyer. Additionally, we're just going to briefly cover Ojai also had its own RSO, which actually was in effect April 28th, 2023. Like Oxnard, it sets the maximum yearly rental increase at 4%. So landlords could increase rent once every year, 4%. So the exemptions are, government subsidized housing, most single family homes or condominiums, duplexes where one of the 2 units is occupied by the owner, institutional properties, and hotels and other types of transitional, properties. So a big question is, can a landlord raise my rent by more than 4%? And so landlords, unfortunately or fortunately, can apply to the community development director for an increase above 4% if the landlord contends that the limitations on rental increase will prevent them from receiving a fair and reasonable return. So the important thing here is a landlord must notify tenants if they are even applying to increase their rent above 4%. So you should receive notice. Additionally, Ojai has just cause tenant protections, like what we discussed before, that lays out the no fault evictions. So if you're under it, you may want to read here. So it is more inclusive, as we mentioned, the 30 days to qualify is more inclusive than the TPA. And you also get 2 months of rent or $5,000, whichever is greater, if you have to relocate based on a no fault eviction. And so it's the same types of exemptions, but there is a lot of information here, and there is a good link here to read more about Ojai's rent stabilization frequently asked questions. So here's just a quick eviction process overview. The important thing to know is that eviction is a legal process. Only a judge can evict a tenant. So we hear this a lot, and self-help evictions, which would be, for example, locking out the tenant, shutting off their utilities, that's illegal. They can only go through the court to evict a tenant. Additionally, landlords must serve advance written notice before filing an eviction. So a notice is a warning, not an eviction. So if you receive a notice, you don't have to leave right away. It just means that you do have to take certain steps. The tenant can and should respond in writing. For example, refute false allegations, inform the landlord of legal defenses, or even negotiate if possible. If a landlord files an eviction lawsuit, you would receive an unlawful detainer, and the court would mail the tenant a summons. So when you receive an unlawful detainer, or someone that you're assisting receives an unlawful detainer, it's important that they seek legal help right away, because they only have 5 business days to respond, or they lose their case by default. And so we have a guide to responding here, but I'm also on the next slide have some more additional resources. And so here's some legal aid resources in Ventura County, and all of these have links. So you can click on them, you can read more about it, and their numbers are here. All right, so that is the end of the presentation. Here's how you can contact our office if you have any questions. I will say, if you're reaching out to our counselors, unfortunately, given the pandemic, we're a little bit backed up on our phone calls, and it's often hard to get back to folks right away. But I will say, if you send an email, you're going to be responded to a little bit quicker right now. So I would suggest an email. Of course, if you have to call, please go ahead and call. But if you want a response a little bit quicker, send an email. All right. Let's see, what time is it?
Thank you so much.
Of course.
And you have offered to provide a copy of these slides to everybody, correct?
Yes, definitely.
There's so many details that I think will be helpful for people to look
Yes.
over again. If you don't mind, stop sharing your screen.
Oh, of course. Let's go ahead.
And we have just a couple of questions that in the chat. I think the first ones were answered, but just to repeat to make sure we're clear.
Yeah.
Can affordable housing in Simi Valley not accept Section 8?
So my understanding is it's illegal for anyone to not accept Section 8 housing choice vouchers based on that 2020 new law.
Wonderful.
And so, yeah, and so if you're experiencing that, reach out to the Housing Rights Center's counselors, and we can, go ahead and make sure that you have all the information available to you.
Perfect. Thank you.
So,
and the next question is, are there any circumstances that would require me to disclose the details of my disability?
yeah, so as we talked about, you don't have to disclose your disability, but you will have to talk about the impact that the disability has on your ability to perform. It limits your ability to live in that housing in some way, right? So you would have to say, because of my disability, I don't have to name it, and it would be in a doctor's note. This person is requesting to have X, Y, and Z to deal with the impact of their disability. So you do not have to disclose the details of your disability, and the landlord can't ask intrusive questions like that. Exactly, yeah. And so if you have more questions, please reach out to the Housing Rights Center.
Thank you. And then can someone who rents a 2-bedroom condo still market that they would prefer to live with a certain sex when renting out the second room?
So from my understanding, and this, if you are renting this out, you maybe want to consult a little bit on an actual attorney to give you this information, because it could have legal ramifications, and I wouldn't want to lead you in a place where you're in that situation. But from our understanding, if you're renting out 1 bedroom in your condo or your single family home, and you're renting out 1 bedroom, you're basically looking for a roommate and you're sharing bathroom or kitchen facilities, that's pretty much the only scenario where you can request to live with someone of the same sex. So it wouldn't work if I was requesting to live with someone of the opposite sex. But if you're requesting a roommate of the same sex and you're sharing bathroom or kitchen facilities, you can advertise for a roommate of the same sex.
Thank you. That does make sense. Asking about getting a copy of the slides. So everybody that registered for this seminar, I should have your email in the system. And I will send out an email to everybody later this week with a link to the recording as well as a copy of the slides. So you will automatically get those from you. And then the last question is, what is the maximum allowance for rent for Simi Valley?
Yeah, and that's a great question. So as we talked about, it really depends on your specific property. So sometimes, you could have someone right next door to you and their property qualifies for different protections than what you do. But at the very least, you would normally be covered by the TPA, but of course it depends on when the unit's built and certain factors like what we talked about. So that's a good scenario if you're given a rental increase, maybe to contact one of our counselors or one of the resources that we put at the end of the slide and get more information about that.
Wonderful, thank you. I think the key really is in so many of these scenarios is to reach out and ask for advice. And I think we need more Housing Rights Center staff in Ventura County, and maybe some office hours that we could have locally would be wonderful. So that's something we can work on.
Yeah.
But I just thank you so much, Margot. This was such an important presentation, just chock full of really good information. So I thank you on behalf of everybody, and I hope everybody will now know about this wonderful resource and get their questions answered. So I thank you all and have a wonderful evening.